right, welcome back. So, we're continuing on with chapter 8. So third part, right, the first two were last week. And we continue essentially our discussion of the standard of review. We covered most of the important stuff last week. And we'll try to make this week somewhat shorter because it's actually a lot simpler. But you should definitely use that as an invitation to reread the beginning of chapter 8, because most of the stuff that we saw that's important was in the readings for last week, right? Because you have the entirety of the discussion on Vavilov, which is the current framework for reviewing an administrative decision. You have the discussion of reasonableness review and correctness review, all of which is extremely important, and which you should go over again, right, to the extent that there's less material and less me talking in these videos for this week. We saw the nature of the exceptions, right? That was the important stuff. We said there's a presumption of reasonableness under Vavilov, and then we said there's 5 exceptions, right? They're at pages 448 and following in the readings for last week. So Vavilov changes everything in that there's a presumption of reasonableness review. So it's no longer a bucket with some stuff that's subject to correctness review and some other stuff that's subject to reasonableness review, as it was under Dunsmuir. Now there's a presumption of reasonableness review. So by default, it's reasonableness review unless you fall in one of the exceptions. It's not categories under each. It's default reasonableness and then exceptions. We saw the exceptions last week, right? 2 of them have to do with legislative intent. So first, if you create a different standard in the legislation, so if the legislation says, right, this decision will be reviewed less deferentially, that shows an intent of the legislator, which we said is the reason why you have reasonableness review in the first place. The presumption of reasonableness review is because there's an assumption that if the government created something else than a court, to do something that a court would otherwise do, it's because it assumes that new body to be more expert, more specialized, and therefore, right, will not subject that to stringent review. So, if the government shows a different intent, so to have less deference, correctness review apply, it's one of the exceptions under Vavilov. Then you have a statutory right of appeal, which is the same thing, right? The government shows an intent for less deference to be owed by creating a review mechanism, an additional, more stringent review mechanism through an appeal. These are the first 2. They both have to do with legislative intent. Then you have 3, which have to do with other stuff, often grouped under the rule of law, right? Really important stuff, which we saw throughout the term, often means that it has a constitutional nature or source. And that's why it's important, like procedural fairness, right? Like jurisdiction, when it's constitutional and important. So the latter 3 out of the 5 have to do with that, right? And you have, right, first constitutional question, so anything that's constitutional, again, Section 35, the Constitution, 90, 91, 92, the Charter, all that not subject to reasonableness review. Then you have questions of law of central importance to the legal system as a whole, right, which we talked about quite extensively, means it has to be first a question of law, right, not fact or application to fact. So the meaning of a statute, the interpretation of a statute, for example. And it has to be of central importance to the legal system as a whole. So first, really important, serious, and to the legal system as a whole. So it has a much broader impact than the one case. For example, it's interpreting a really important law, and that will decide a lot of future cases which arise under that law. And the 5th one is, right, the jurisdictional boundaries between different decision makers. And we said that's the last thing, at least officially, right, won't repeat that, having to do with jurisdiction, which is still subject to correctness review. Everything else technically under jurisdiction is subject to reasonableness review. So It's very specific things. They're jurisdictional boundaries between decision makers. So it's a decision as to whether not just that decision maker has the power to decide what it decided or wants to decide, but it's a question as to whether it or some other administrative decision maker, not a court, has that power. So again, you should review that. Then you have a very lengthy discussion around page 470 of the factual and legal constraints. And that's very important, right? You've got lots of heads of possible stuff that we covered for last week. All that is important in assessing, right, whether a decision is reasonable. Right now that you've decided that the presumption of reasonableness review applies and that it is not rebutted, how do you conduct reasonableness review? Well, generally what it means is that the decision has to be consistent with, quote, the factual and legal constraints bearing upon the decision maker. And the way in which you assess that is with, right, the 10 pages of factors that you have, which are essentially the factual and legal constraints bearing upon the decision maker. So take your time to go over that again, right, because it's important. This week is lighter, looks at a few more specific issues with the standard of review, mostly putting it in historical context. There's lots of other places in the book where the author does that. We skip them because they're not that important. And we're focusing on the ones for this week because I think they're illustrative of what the current position is. So, first we have a discussion of privative clauses, right, which is under the first two exceptions that we saw, right? So we said under Vavlov you've got the presumption of reasonableness review. It can be rebutted in specific circumstances. The first two, as we said, have to do with legislative intent, right? So if you have a legislative standard, it's different than it suggests something having to do with non-deference. Same thing for our statutory right of appeal. A privative clauses is extremely similar to that. It's essentially a clause that that removes or purports to remove, right, some review. So the default thing will be it's a clause that says this decision, the decision of this decision maker, is final and without appeal. That's the traditional example of a privative clause. That is helpful in that it shows the government's intent, right? If the government says this decision is final and without appeal, well, clearly the government intends for deference to apply, intends for little review to apply, and therefore intends for that decision, right, not to be subject to stringent review. So for sure, correctness review will not apply. As we saw, though, a clause that says this decision is final and without appeal is not in itself valid, right? It will limit the right of review as much as is constitutionally allowable, but not more, because as we saw, the Constitution limits that, right? The Constitution says you cannot fully oust the inherent jurisdiction of the court. So to the extent that it's something that you can remove from the purview of the superior courts, right? And that remains relevant. We saw that in the first few weeks, but it remains relevant. So first, superior court has inherent jurisdiction. If you don't know where to go, you go to the superior court. It's the default court, inherent jurisdiction. Then, right, there's some stuff that you cannot remove from the superior court, right? That's somewhere else, sending someone somewhere else. And we saw the principles of that, right, under constitutional jurisdiction. So if you remove too much from the superior court, then it's no longer a court of inherent jurisdiction because you've removed too much. It's no longer default because the default's too narrow, and that's not allowed. And we also saw that the stuff that the superior court had jurisdiction over at confederation is stuff that you can't remove. Anything else you can remove, but subject to the inherent supervisory jurisdiction of the superior court. Because the Constitution says a court supervises everything, not an administrative agency that didn't even exist when the Constitution was written, right? So the court retains its supervisory jurisdiction. So a clause that says this decision is final and without appeal of the tribunal will not be valid in full if it purports to prevent the Superior Court from conducting any review, because that's not constitutionally allowable, but it will remove as much review as possible on whatever you can, so say it's a discretionary decision, for example, and in conducting review, the court will take into account that intent by being far more deferential. Okay, so the language of the clause will of course be relevant, right? Because that's how the government most clearly evidences its intent. So, right, again, if it's strong language, such as this decision is final or fully final and without appeal, it's very strong language, clearly evidences an intent for lots of deference to apply, and depending on the language being used, it will fall somewhere else upon that spectrum, and the courts will be, right, more or less deferential or likely to be deferential. Nonetheless, as is mentioned 489, the language is not dispositive because it's used as an indication of intent. So the language is not in itself relevant. So for example, what I just said, if it says it's fully final and without appeal, that's not constitutionally permissible. So, of course, the language there doesn't fully govern. Otherwise, if it did, it would make it what it says, make it fully final and without appeal. So the language is not dispositive, and it's because it's used as an indication of the government's intent. So it's a corollary. It's an indirect way to determine intent. It's not something that's directly important in itself. Okay, then you have a discussion of the historical context of the right of appeal, which again is one of the limitations under the Vavilov framework. So it's one of the first two where the government evidences its intent again. So we saw that. So it creates further review, right? Essentially, we'll generally narrow the standard of review, therefore make it correctness. So if it says, instead of saying that, right, it's the opposite intent. Right now it says, this decision is subject to appeal or review, most often appeal by either an administrative decision maker. So you'll recall my immigration example, you've got the Immigration and Refugee Protection Board. That's where you show up if you've got an immigration problem. Right? The two divisions are refugee protection and immigration. That's where you show up. Anything having to do with that, you have to go there, not the Superior Court, there. Then, if you're not happy, it says you can go to the appeal board. So either refugee or immigration, appeal board, right? And that is a statutory right of appeal. And on top of that, the government will say, that decision maker can do whatever they want. They can fully disregard the initial decision. Well, clearly, that's an intent of the government for there to be less deference upon the initial decision maker, the board, when it's before the appeal board. So, shows intent, shows the opposite intent, and on top of that, can indirectly show that the government doesn't want the court to interfere. Because now it's provided an administrative appeal. Could be a court appeal. In which case, of course, the court would intervene. But now it's created an administrative appeal. So that shows it wants less deference for the refugee board to have upon appeal. But then because it gave people a right of appeal to an administrative entity, another one, that can indirectly show that it doesn't want the courts to intervene, right? Because you've had two chances now, two full chances before two decision makers, right? One of which is more sophisticated than the other. Therefore, that suggests that before a court, right, now you've had your chance. There's no additional review. So that would show less deference, for example. of the court. And in fact, for example, the federal court, which is the relevant decision maker in that example, you don't have a right to judicial review. You have to seek it. So it's upon permission, and that's one of the ways in which you can limit it. So right of appeal, right? If it's a right of appeal before a court, of course, shows an intent for less deference to be owed. If it's before an administrative decision maker, my example might show more court deference to be owed in the end. And there's reasons for that, right? You might think why, especially with, we said on Vavilov, right, with the presumptive standard of reasonableness, which is a presumption of deference. It's a presumption that, as I said, that's what grounds it. It's a presumption that the government created an administrative decision maker precisely for deference to apply. So why in the world would it want the statutory right of appeal? Well, it might be that a court is more competent to review than a specialized decision maker, especially if it has people who are not lawyers, which will very often happen as we discussed. That's one example why it might make sense, or it wants, right, to benefit from the experience, or it's worried about the decision maker getting what we call tunnel vision, so getting too focused on overly specialized issues, and therefore, right, not apply the law necessarily in a way that's consistent with broader context, social context, policy context, constitutional context, and therefore it's better done by a court. Okay. If it's an actual appeal, that will change everything, as we'll see. And that's not something we've discussed so far, but it's something that's actually important. So, if it's an actual right of appeal, and that's important, right? There's all sorts of ways that you can show the same intent indirectly. So if you have more judicial review, if you have a statute that says it's reasonableness review, if you have a statute that says the court will owe deference, all that shows an intent for deference to apply, an intent for the court to be less interventionist. All that, right, has to do with review, of course, with the role of the court in reviewing the decision, but it's not an appeal. It shows the same intent, but as we'll see, there are different rules. So if it says you have an actual right of appeal before a court, right, it says that. So two things there. First, appeal, second, a court. If it says you have a right of appeal, which will very rarely happen, of a decision of the core tribunal before the superior court, then you'll have very specific rules apply. It falls under the same category, which we said is the second exception under Vavilov. And it's related to intent, right? So appeal is the court will review it. Of course, that shows less deference, therefore correctness. But, in fact, it's not correctness. What you'll have is the standard from the Hausen v. Nicolaisen case, which is in a specific context. Again, it has to be appeal, it has to be a court, which is the usual appeal jurisdiction. So, for example, say you have an actual court. So you go to the superior court, right now you get your trial, you do your stuff, you get your witnesses, your documents, and you plead your stuff. Then you get a decision, and the decision says you lose. Now, you think that's bad. You think that the judge made a mistake. You have a right to go before the Court of Appeal, which is, again, of constitutional jurisdiction, right? The Ontario Court of Appeal. Oftentimes you'll have a right to go there. Not necessarily, but often. And you'll have a right to say there has been a mistake. And there will be a standard that will apply, right? Because it's not a new decision. You don't get to start over, right? You're just asking for the Court of Appeal to decide if a mistake has been made. So in assessing whether a mistake has been made, right, then the court will apply a certain standard. Well, that standard will vary depending on the nature of the issue, as you all know, right? If it's an issue of law, there's less deference because the Court of Appeal is an expert on that. If it's an issue of fact, there's lots of deference, because fact means the assessment of the trial judge of the witnesses and documents that were before it. And that is a specific expertise or purview of the trial judge, namely because the Court of Appeal doesn't have the people before them and cannot assess their credibility. If it's mixed fact and law, it will be something in between, right? That is different from judicial review. So the appeal standard of review is different from judicial review, and it's more interventionist. So at the more deferential end of the spectrum, on, say, an issue of fact, it will be what we call a palpable and overriding error. Still is not interventionist, right? So an issue of law will have to be correct if it's not intervened, but on an issue of fact, it will be palpable and overriding error. So less intervention, but that is still more interventionist than judicial review generally. And in judicial review, you have something similar, of course, because you have an administrative decision maker, which is body number one, makes a decision, has a record, the people, the documents. Then you go to courts. Of course, it's the same thing. You're reviewing something that someone else did, like in an appeal, and you have to pick a standard to do that reviewing, and that will depend on the nature of the issue. But judicial review is by default more deferential. The standards that apply on appeal, which I just mentioned, allow for greater intervention than upon judicial review. So, to the extent that a statute specifically says the superior court, you have a right of appeal before the superior court or tribunal, then, right, that tribunal, superior court, will apply the housing standard, will apply the standard as though it were an actual appeal. The same standard that would apply if the Court of Appeal reviewed a decision of the superior court. And that's different from judicial review. It's not correctness or reasonableness. It's what I said, palpable and overriding error. And that allows for greater intervention. And again, right, appeal, the magic word appeal is important in showing intent. It intends for less deference, and that less deference manifests itself in actuality with that standard. However, right, it also, the magic words, has the impact of allowing for a fully different framework to apply, which is the framework upon an actual appeal, as though you were before the Ontario Court of Appeal, not the usual Vavilov framework, which is reasonableness and correctness. And that's the only place. If the government shows intent differently, right, by saying this decision is final and without appeal, shows intent, right, or creates a right to judicial review, which will let the court intervene more. All that will mean that the review will still happen pursuant to the Vavilov framework of reasonableness and correctness. It's only if it's that specific context that it's different. Okay, then you have a discussion of the purpose and nature of the tribunal. You have the historical review of how that changes the standard of review. For our purposes, it's no longer really important, right? And that's because there's a presumption of reasonableness, right? So back in the days, it was important to determine the nature and purpose of the tribunal, because you had two buckets. Sometimes it was correctness, sometimes it was reasonableness. And of course, if you had a specialized expert tribunal, that would suggest that it has specific expertise, and therefore that the court should defer to that expertise, which it doesn't have, by applying reasonableness review. Now that's much less relevant because you have a presumption of reasonableness review. Now we assume, essentially, that there's a specialized expertise. That's what I said earlier. That's what underlies the presumption of reasonableness under Vavilov. It's an assumption that the government created the tribunal for a reason, which are all the ones we saw: expertise, effectiveness, right, being different, all of that. And therefore, that means that there's a presumption that the standard will be reasonableness. So For that reason, the nature and purpose of the tribunal is no longer all that important. What is important is what we call polycentricity. And that is, essentially tribunals that make decisions, and that's a very fancy word, that have to do with many things, and oftentimes many things that exceed the nature of, right, the dispute before them. So, for example, they have a dispute, right, that will be about car accidents, for example. But they'll have to make a decision that's essentially policy-laden about compensation, but about whether compensation should be afforded. And that will have, right, generally a broader impact. That's an example. The typical example of that is municipalities, which, as we said, are essentially administrative entities, because municipalities, so cities, right, are not a thing in the Constitution. The Constitution says there's provincial, there's federal, this is half and half, right? It doesn't say you've got municipalities, which would be a third thing. So municipalities get their power by the provincial government, so it's delegated authority from the provincial governments. And as you can imagine, same thing as any other administrative entity, right? You delegate power from a constitutionally appointed level of government to something else. That's administrative law. Well, if you have a city pass a bylaw, essentially, right, the lawmaking process in a municipality, same thing as if it were a province, right? But it's subject to judicial review because it is an administrative decision. Well, of course, that's much different from a decision that only affects the interests or rights of the parties, right? The body will have to make a decision that is of greater impact, right, than two specific people, and will have to weigh, in doing that, certain considerations that are much broader. They'll have to weigh competing policy considerations. They'll have to consider a lot of things at once, right, everything, and make a decision that's not obvious. And to the extent that that's the case, that's what polycentricity means, right? You're deciding on, essentially, right, issues that have an impact on more people and or, right, various issues bearing upon a specific context, right? So issues of various types, socio-economic, for example, right? That will suggest that the power is essentially more discretionary, because it's subjective. How you weigh these things, there's no obvious answer, and certainly the court won't have that answer. Implicitly, it calls upon a specific expertise, which is another thing that justifies deference, and therefore the court will consider that as similar to a discretionary decision, and therefore often decline to intervene. Okay, then you have the expertise of the tribunal. Again, kind of same thing as the nature of the decision maker. Less important because you still have, right, a presumption of reasonableness, which is kind of a presumption of expertise. Nonetheless, it remains relevant in assessing the nature of the standard that will apply, essentially along a spectrum. So the more expertise, the more deference, because the court is not in a position to conduct the exercise because it doesn't have the same expertise, and therefore will defer to the administrative decision maker. The simplest way, right, is to have specific criteria as to appointment. So if the law says you've got to have a doctorate in chemistry to be appointed to the board, well, that's an appointment criterion, right? It says how you decide who the decision maker is, how you appoint them to the tribunal. Well, that will suggest expertise, of course, right? Because the doctorate in chemistry ostensibly so that you know something about chemistry, right? And that's the clearest and most obvious and usual way in which the government evidences that intent. That intent for the tribunal to have a specialized expertise, ostensibly even more than we would assume it to have by default of the presumption, which, as I said, is built upon that. And therefore, the court will respect that, right? The court will decline to intervene and show more deference. And the other way in which you can show that is to have a process that's more like a court. So, as we said, you can have an administrative decision that counts as one in a multiplicity of contexts, right? The guy at the border who decides that you don't get to the United States because he doesn't like what he saw on your background check, right, which is a discretionary decision, that guy has made an administrative decision, right? He probably doesn't know the law too well, probably has not told you I am invoking Section 28 of this law, and doesn't give you reasons for their decision. That's an administrative decision. It happens in all sorts of ways, and most of the time, it will very much not look like a court, and very much not look like a judicial decision, the reasons for it. When it does, though, it strengthens a claim to expertise. It legitimates some expertise, right? Because first you're applying it through that process, but more importantly, you're showing sophistication. You're showing that the people who have a doctorate in chemistry also understand something about procedural fairness, and therefore they set up a very sophisticated and adequate mechanism by which they apply their chemistry knowledge, which is the court, right, the administrative tribunal, and that will strengthen that claim and therefore make it more likely that the court will show expertise. And that you have two other things mentioned at 502, which is if the tribunal deals with a very narrow set of issues, often, right, says every day, often makes these decisions consistently, that will also show expertise. That's the nature of expertise, right? If you're doing the same thing all the time, that's how you get to know about it. There's another mentioned around 502 about within that expertise, right? Of course, and we'll do some erasing as I'm saying this, the tribunal will have to apply it, right? So if you have a tribunal with specialized expertise or deemed specialized expertise, which then starts applying the Constitution, well, of course, the expertise issue won't be particularly relevant because then it's not applying that expertise, it's applying the Constitution, essentially, right? And therefore, right, to the extent that it's not being used, the specialized expertise, you'll have, right, less deference, certainly. Actually, you'll have correctness review because it's a specific exemption under Vavilov. Okay, then you have a discussion of jurisdiction. As we said, there used to be what we call pure jurisdictional issues under Dunsmuir, which was the preceding framework before you had Vavilov, and that was very specific. You had to have a pure jurisdictional issue because, of course, it's essentially an error of law, which usually is subject to correctness review, right? If you have a statute that says you have this power and the decision maker exercises a power that's beyond that, it's essentially an error of law, right? It's essentially you interpreted the statute wrong and decided that you have a power you don't have. And that's a legal issue and therefore would be subject to correctness review. In the real world, though, as it turns out, this does not happen very often because very often the interpretation of the statute first won't be clear, right? So the interpretation of what power you do have will not be clear. And therefore, you'll have to look at the specific context of the case. You'll have to look at the general context of the statute, at how much deference you're owed. And then you're getting into an issue that's murkier and therefore should not be subject to correctness review because it's no longer an issue of law. And that's essentially why the Supreme Court in Vavilov eliminated the category of pure questions of jurisdiction. It's because they rarely show up as such, and we're creating trouble for courts conducting judicial review because the parties were systematically claiming that. And that's why the court says that now presumptively issues of jurisdiction, even issues of jurisdiction, are subject to correctness review. And that's at pages 504 and 5. And you have that mentioned in a number of ways, right? One of them is at page 505 at the end of the section. The author says this is likely a positive and clarifying development, as no satisfactory test has ever been formulated for determining which decisions are jurisdictional and which ones go to demerits, merits being the substance, the nature of the case. And that's because most issues of jurisdiction are not just about jurisdiction and go further than that. Okay, then you have questions of law, right? That's no longer, again, a separate category under Vavilov. It is under housing on an appeal, on an actual appeal, before an actual appeal court, not under Vavilov. So, issues of law, for the same reason as jurisdiction, are now subject to reasonableness review. So, issues having to do with, right, the interpretation of a statute, same thing. The interpretation of a statute, first, the statute that the decision maker is interpreting will usually be their statute. And so they have expertise, right? So usually on appeal in an actual court, right, the Court of Appeal has better or similar expertise upon an issue of law, right, because it knows the law, right? It doesn't have a disadvantage as it does for issues of fact with not having the witnesses before it, for example. That's not the case in administrative law. Why is that, right? It's because the main law that's being interpreted in the administrative system is the law that constitutes the decision maker. And you can rightly assume that the car tribunal is deemed to have a specialized expertise in assessing the Car Tribunal Act. That's why it was created. If it was created to apply the law, right? So the law will say, these are the criteria where you get compensation if you get into a car accident. Well, it's been created to apply that law, and so we can rightfully assume that it is, right, it has specialized expertise to apply the law, right, including its jurisdictional issues. And that's why you have the presumption of reasonableness review, even on questions of law, right? Of course, you'll have the two sub-exceptions which are specifically provided for under Vavilov, which we just discussed, right? And these are first constitutional questions. That's the first exception, the third exception, under Vavilov specifically provided for. So if the law being interpreted or applied is the Constitution, then, right, you won't have reasonableness review apply. And the second exception is a question of law of central importance to the legal system as a whole. As we said, right, won't repeat what that means. Means it's broader, means it's important. And in that context, you're under the fourth exception. So that's one of the questions of law, of legislative statutory interpretation that will no longer be subject to reasonableness review because you're rebutting the presumption, therefore you fall under correctness review. Every other question of law falls under the default presumption under Vavilov. Okay, then you have a discussion of the issue of a question of mixed fact and law, which again is relevant within the statutory appeal framework, not anymore really within the framework of Vavilov. Then you have questions of fact, right, and unsurprisingly, as they are in the appeal framework, these will be subject to even more stringent, if possible, review. And that's because the decision maker, as a court at first instance does, right, has a specialized privileged position to assess them because it has the witnesses and the expertise to assess the documents that are before it. So they are, quote, automatically granted judicial deference, right? Unlike in an appeal where it's palpable and overriding error, in administrative decision, you have reasonableness review, which applies. Okay, then you have a discussion of discretionary decisions. We won't cover that again. We discussed it pretty extensively, right? The nature of discretion is that you're granting a decision maker the power to do whatever they want. So oftentimes, right, to apply or not apply the law, in a specific context often has to do with favoring justice, right? And often they can do nothing at all. They can decline to exercise their power. And it's much broader than another power provided under the law, and so the courts will show deference. Nonetheless, there remain, as we saw, certain constitutional limitations. So it doesn't mean, even if that's what it says, that the decision maker can do whatever they want. They can't. They have to respect certain boundaries, right, which are abuse of discretion in certain constitutional issues. But by default, right, you have more deference by virtue of the characterization of an issue as discretionary. And that's it, really, for this chapter. At the end, you have a short description of correctness review, which is placed somewhat awkwardly in the chapter, I think you'll find. But interestingly, it raises one point that we might not have specifically discussed, right? And that is that you can conduct the exercise again. That's what correctness review means. So under a reasonableness review, it's complicated, right? As we saw, no one really knows what it means, including the Supreme Court. It's kind of intuitive, but not that clear. And one of the things that it means is that you're trying to intervene as little as possible, right? You're trying to get as shallow as possible, right? So you don't want to get deep into it. You want to look at the decision itself. It's that sufficient for it to be reasonable, you stop there. If not, you look at the record. If that's sufficient, you stop there, right? You try to go as little as you can into the substance of the decision and everything else, right? Of the record and everything else, so that you show deference, so that you don't conduct the same exercise again. Well, this is described at the very end of our section for this chapter. That's the opposite of what you do under correctness review. Under correctness review, there's no deference. The court doesn't have to do all the gymnastics of this. It starts over. It puts itself in the shoes of the decision maker, looks at what it had, right? No shallow stuff, right? Can get all the way into the record. Look at all it had and says, if I were there, what would I have done? And if the answer is different from what the decision maker did, it's one of the ways in which it shows no deference, by conducting an exercise. If it's not the same decision, substitutes its decision for that of the administrative decision maker, period. It's the second way in which it doesn't show deference. And that will mean, that will not necessarily mean, right, under remedies, though, as we'll see, and as we mentioned in the term, that the remedy is different. It will still mean that you don't substitute your decision directly. It might mean that you quash it and return it to the decision maker. So you show no deference by canceling and validating the administrative decision, but you'll still do the default remedy, which is to quash and return, to cancel it and send it back to the initial decision maker for redetermination, because you still have to defer to the general administrative framework, which says that the decision maker, even if one of them made a mistake, is better placed than the court to decide an issue within its expertise. And we will stop there for this week.